Has Johnson & Johnson manufactured products that contain asbestos?
We've been kind of at the ground floor of litigation involving Johnson & Johnson talcum powder products, and what we've discovered through the last 10 years of litigating these cases is that J&J has historically manufactured body powders. Probably the one that everybody's most familiar with is Johnson's baby powder that contain asbestos. J&J also manufactured another popular body powder called shower to shower that contain asbestos as well for many decades. Most recently, within the last year or two, J&J originally pulled talcum powder off the shelves, the baby powders and any other products that they manufactured in the United States. And then even more recently, they've taken those products off the shelves worldwide. So no longer can anyone purchase powders that were made with talc, anymore in 2023. But what we've learned from handling these cases for the last 10 years or so is that the talc that was put into used to manufacture J&J's baby powder and shower to shower, that it's a mined product, and it's been mined in places like Vermont. It's been mined in China. There's been some Italian talc mines that have produced some talc, and talc is a naturally occurring product, and asbestos is a naturally occurring product, and it's been demonstrated time and time again through the medical and scientific literature, the geologic literature, that talc and asbestos form in the same places. And so when they mine the talc, they also mine asbestos as a part of the talc.
So what diseases have been caused by the asbestos that's in J&J talcum powder products?
The most commonly associated diseases that have been proven, again, I think by the medical and scientific literature, is ovarian cancer. Thousands of women have been diagnosed with ovarian cancer, over the last 40, 50 years. Unfortunately, because it was not widespread known knowledge that J&J's products contain asbestos, women and all people continue to use it for forever. And more recently, in the last 20 or 30 years, the medical and scientific literature has made a causal connection between ovarian cancer and exposure to talcum powders. So that's one. And then the other one is mesothelioma, which is most commonly associated with asbestos exposure. Asbestos is the only known cause of mesothelioma.
Have there been any lawsuits or jury trials regarding asbestos in Johnson & Johnson talcum powder products?
There are thousands of lawsuits that are currently pending against Johnson & Johnson associated with asbestos exposure from baby powder, shower to shower, and any other talcum powder products that they've made. There have been, to my knowledge, approximately 50 cases that have gone to trial, probably roughly half and half between ovarian cancer cases and mesothelioma cases. There have been numerous jury verdicts in favor of plaintiffs in those cases. Those jury verdicts have totaled in the billions of dollars when it's all added up. There, of course, have been a few defense verdicts as well, but there are thousands of lawsuits that are pending. I believe the latest statistics are somewhere in the upwards of 38,000 ovarian cancer cases that are currently pending somewhere in the United States, and I believe about 350 cases, mesothelioma cases. You may ask, well, why is there a disparity between the ovarian cancer matters and the mesothelioma cases? It's because mesothelioma is so very rare. It is a disease that's diagnosed in approximately 3,000 people per year in the United States, and there's just fortunately there's far less people afflicted with mesothelioma, and of course both diseases are fatal. Mesothelioma is universally fatal. I mean, everybody will unfortunately probably die who gets that disease within 18 to 24 months. Ovarian cancer can have a much better outcome. Of course, it can be fatal as well, and frequently is fatal. But if it's caught early, there's a lot of treatments that can be provided. And ovarian cancer is just typically a more common disease process. But essentially, between these two disease processes, there's at least 40,000 cases that are currently pending against Johnson & Johnson from various women who have developed ovarian cancer, and men and women who develop mesothelioma from using the product.
Did Johnson & Johnson go bankrupt because of these lawsuits?
Johnson & Johnson did not go bankrupt. Johnson & Johnson is a Fortune 50 or Fortune 100 company. It is flush with cash and is worth hundreds of billions, if not into the trillions of dollars. What Johnson & Johnson did in order to try to avoid all of these lawsuits and try to avoid having to pay fair value to each and every claimant, and B, to try to expediently resolve the cases, it went into Texas and employed a procedural device called the Texas two-step, or also known as a divisive merger. And essentially, and it's more complicated than this, but I'll try to keep it as simple as possible. It formed two other companies, and one company was intended to dump all of the liabilities, and specifically the talc liabilities, into this company. And then the other company got all the assets, got the product line, got everything that J&J and its subsidiaries did, and business would continue as usual, and they would never miss a beat. The company that got all the liabilities was destined for bankruptcy. That was the plan all along. So J&J did this with its subsidiary, and it created these two companies, and then the company destined for bankruptcy was immediately moved and was headquartered in North Carolina. And then I believe 2, maybe 3 days after the creation of the company and the transition to North Carolina, it declared bankruptcy. And as a result of that, and there was some legal maneuvering that had to happen in order to get to that point, but the bankruptcy was eventually moved from North Carolina to New Jersey, because J&J is headquartered in New Jersey. J&J's subsidiary was also headquartered in New Jersey.
So what's the current status of this LTL bankruptcy?
Right now we have some great news. About 2 weeks ago, the Third Circuit Court of Appeals, well, let me back up. The bankruptcy court, a group of creditors, and that's what the asbestos claimants are. They're just creditors. And they had asked the bankruptcy court to dismiss the bankruptcy or to lift the stay as to J&J. The impact for that would be that J&J would be back in the tort system, and people could continue to litigate their cases on an individual basis in whatever court they filed their case in. The bankruptcy judge in New Jersey decided not to do that, denied the plaintiff's motion, said he said that he thought that the bankruptcy court was the place to be, and that claimants would get a much more expedient resolution if cases were resolved through that system, because over the years only 50 cases have been tried, and that it would take decades to try just the current inventory. Of course, we disagreed with that considerably, and there's a process that allowed us to go straight to, or allowed the claimants to go straight to the Third Circuit Court of Appeals to appeal that denial of the motion. And about 2 weeks ago, Third Circuit Court of Appeals issued a decision and said that bankruptcy should be dismissed. And I won't get into all the details, but essentially it concluded that the new company was not in financial distress. And in part, the new company was not in financial distress because its parent company, J&J, was not in financial distress. And J&J had agreed to provide funding to the new company, quite frankly, and well into the future, that would make it very unlikely anytime soon that company would be in financial distress under the current circumstances. So ultimately, all of these cases will be returned to the tort system, and people will be able to litigate their cases on an individual basis, as has been done in the past. There's still some appellate procedure that's in place. Last week, Johnson & Johnson moved for what's called rehearing en banc, and that means that ordinarily an appeal is decided by 3 appellate judges. And you got to get 2 out of the 3 in order to win. I believe that this decision was decided 3-0 by that panel. But an aggrieved party by a panel's decision can ask the entire group of appellate judges in that circuit, which would be the Third Circuit Court of Appeals, to grant a rehearing and essentially try to decide the issue differently than what the original panel did. Hearing en banc is rare when one's granted. It's typically not granted. And quite frankly, we have very little expectation that it'll be granted in this case, but it certainly could be. If it were, then that would give LTL and J&J some life on this bankruptcy, the procedure that they have employed. But the likely scenario is it gets denied. At that point, then they have to petition for a writ of certiorari with the United States Supreme Court. United States Supreme Court takes very small percentage of cases that it's asked to take. I make no prediction as to what the Supreme Court would do with this, except the odds are not in anybody's favor that files a petition with the Supreme Court, because it just can't take all the cases that are filed. So our expectation and our hope is that by spring, early summer of this year, all of these cases will be back where they belong, and people who have filed claims and have a grievance with Johnson & Johnson will be able to have their day in court.